If you want to know about the lawsuit, though, on the slide up here is a link to our website. There is a slider about the lawsuit, and pretty much everything you want to know about the lawsuit is there. So if at the end of tonight's program you didn't follow something, you want to know something more, it is there. I want to start the discussion of the Obergefell case and this lawsuit with 3 observations. One of the things that's become apparent to me is I deal with legislators in particular, it's unfortunate, is that many haven't thought about the Constitution really since 8th grade civics class, and about all they know is what they were taught in 8th grade civics class, which isn't very deep because it's 8th grade civics class. And so there's some things that we often forget if we ever knew them that are important to understand and that explain these lawsuits. I was just reading an article today about me in the new civil rights movement.org that talked about the insane attorney from Williamson County who is pathetic, insane, hasn't read the Constitution, probably hasn't read the decision. I can't remember some of the other words they used. And as I read it, I thought he probably hasn't read the decision either. And so here are some of the observations. Court decisions only bind the parties to a lawsuit. That seems kind of elementary, but we have to remember that. There may be a lawsuit between me and person X, and what has happened between me and person X may be very similar to what has happened, almost maybe identical, between me and you. But the lawsuit between me and X does not have any binding effect on you. You weren't the party. That's very important, and we'll explain why in a moment. Court decisions may be precedent, but they only bind as the particular issue before the court. So let me go back to my example where I'm suing person X over a contract issue. I have the exact same contract with you. Let's say it's a recording contract. I always wanted to be a singer, a musician. And so I have a recording contract, and I win in this lawsuit. You're sitting over here saying, gosh, if David sues me, I will probably lose because this case will be precedent for my case. But until I actually sue you, until the court actually says, yes, this is exactly the same thing, we don't really know what will happen over there. Now, why that is important is oftentimes the Supreme Court will rule on something and everybody will say, well, that's just like our law. So we're just going to do what the court says. When theoretically you could always say, well, I know my law is exactly like their law, but I'm going to make them sue me. I'm going to make them prove their case. I'm going to make them win against me. Now, often you don't do that because you wind up paying attorney's fees for yourself and attorney's fees for the other side, and you're going to lose. But theoretically, you can do that. When the Supreme Court in Obergefell ruled on the laws of 4 states, only those 4 states were affected by that judgment. Every other state's law is valid until somebody sues them and actually strikes it down, or until their legislature decides to change the law anyway. But that's important to understand. And the only case in Tennessee that was in front of the Supreme Court last summer was the case of Tanco v. Haslam. There were 4 cases, one from Tennessee, Ohio, Michigan, and Kentucky. We're all in the 6th Circuit. Our case was called Tanco v. Haslam. They were all decided under the name of the case, Obergefell v. Hodges, which was a case in Ohio. But each of those cases involved different laws, and so decided different questions for each state. So let's take a look. The only laws challenged in Tanco were laws regarding out-of-state marriages. So the only law that Tennessee has been sued over, the only law that we would say legally and constitutionally has been adjudicated is our law dealing with people who live in another state, get married, and move here. That's the only law Tennessee has been a party to. That's the only decision that's been made with respect to Tennessee law. The question that was not decided in the Tanco case is what's the legal effect of that court decision on marriage license laws for in-state people, the two people who live down the street from you. That law was not challenged in Tanco. It was challenged in the Ohio case and in the Michigan case, but we're not Ohio and we're not Michigan. While what the court said about those laws would be precedent in a lawsuit against our laws, those laws in Tennessee have not yet been ruled on. So, what did the Obergefell court hold? And here's the importance of the holding. You've probably been to marriages where the minister gave up a little homily for maybe 5 or 6 minutes, said, by the power vested in me, you're married. You've been to some places where they maybe went through all of covenantal theology from the beginning of the covenant with Adam, and an hour and a half later, they got to the marital covenant. But at the bottom line, they still had a holding, right? By the power vested in me, you're married. All that stuff from the 3 minutes to the 3 hours is all nice stuff, but you have to look at the holding. And so what did the Supreme Court hold? Well, they held, and this is a quote, the state laws are held invalid to the extent they exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples. They said the laws are held invalid. Now, I saw a couple of you, not over the internet, I can't see you, I promise, but it kind of like, the laws are invalid to the extent. What does that mean? Well, let me just put for you what our law says. Our law says this, quote, no county clerk or deputy clerk shall issue a marriage license until the applicants make an application in writing stating the names, addresses, ages, addresses, social security numbers of both the proposed male and female contracting parties. Now, I don't know who's listening on the internet, but I know most of the folks in here, and apart from me and from Zach, I don't think there are any lawyers in the room. So you're at a great handicap to read that statute and say, does that seem to exclude same-sex couples from marriage because it says there has to be a male and a female? Now, I know that's a tough thing. Put on your thinking caps. And you would probably say, yeah, when Bob and Fred, I don't know which one's going to be the female. When Susie and Sally show up, I'm not sure which one's going to be the male. That would mean, therefore, it would appear that the law is invalid because it excludes same-sex couples. Brilliant. You just graduated from law school ahead of most lawyers in the country. I mean, when after all, lawyers don't know what the word is, it's probably hard to figure out some of this other stuff. But look at the contradiction of what the court said. The court has a second holding, and here's what they said a few paragraphs later. They said, this court in this decision holds same-sex couples may exercise the fundamental right to marry in all states. Now, they just said this, right? We hold the laws are invalid. We hold that you can get married under the law. That leaves us with two questions. How do you exercise a right to marry, which was the second holding, under a law that under the first holding has been held invalid? How do you get a valid marriage license if the law is invalid? And then there's this other interesting thing. I was talking with Zach today, who's a lawyer, and so sometimes we have lawyery discussions. And he said he was talking with some of his other law friends about the statement that the law is held invalid to an extent. How is a law invalid to an extent? Can a law be more or less constitutional? Now, I know that all of you in this room have either had a mother or you are a mother. And I would like to ask the women, have you ever known a woman who was pregnant to an extent? More or less pregnant? No. What's very interesting is Chief Justice John Marshall, who wrote the Marbury versus Madison decision that gave us this concept of the judiciary reviewing laws to determine their constitutionality. He said, a measure may be more or less wise, depending on the circumstances, but it can never be more or less constitutional. And you know where I found that statement was I found that statement in the majority opinion in a case from 2011 called NFIB versus Sebelius. That's the case in which the Supreme Court said that Congress could not threaten states by withholding money if they did not expand Medicaid. That was an attempt to commandeer a state government to dictate to them what they should do, and it was in violation of the principles of federalism. And it was in that case that I read that quote, and in that opinion, it was joined by Justice Kagan and Breyer, who are two of the judges who wrote that the law is invalid to an extent. A law can't be more or less constitutional, but it can be constitutional to an extent. Do you see some of the irrationality and illogic that we're finding in our court? That begins to happen when you try to reach a result and then figure out how to get back to the answer. Now, let's take a look at Tennessee marriage laws. Okay, we've already put this up there, but let's work through this for just a moment. Here's the statute we've already looked at. It says that to get an application, no clerk can issue an application unless it has the name of a male and female on it. So if the words male and female are invalid, which is what the Supreme Court said, right? They said state laws that exclude are invalid. Then what words took their place? There's the statute. There are the words male and female. If those words are invalid, what words took their place? Who can be the contracting parties now? And who can insert words in a statute? Well, let's take a look at that for a moment. Under the state constitution, only the General Assembly can prescribe the duties of a clerk. The Constitution of Tennessee says the qualified voters of each county shall elect for terms of 4 years a county clerk. Their duties shall be prescribed by the General Assembly. They're not prescribed by the governor. They're not prescribed by the Supreme Court. They're not prescribed by Congress. They're prescribed by the General Assembly. If the General Assembly passes no laws giving the clerk anything to do, then the clerk gets elected every 4 years and sits at home. They sit at home because there's no duty, so there's no budget, so they can't even have an office to go sit in. On the basis of what law passed by the General Assembly can a clerk issue a license to anybody if the law is invalid, which Obergefell held? On the basis of what law prescribed by the General Assembly are our county clerks issuing any marriage licenses to anybody? Well, okay, what law? What's the law? Where is the law? Let's find it. You remember the little Wendy's commercial, those of you in the room that are over 50s? Where's the beef? Where's the beef? Remember, well, where's the law? I want to see the law. Where's the law? Well, there are two answers to this question as to how the clerk can be issuing licenses. Again, here is the statute. And the question would be, well, can you just simply elide, that's a nice legal word we use, or delete, the words male and female? and then interpret the remaining words, contracting parties, to mean any two people regardless of their sex. So as you see in the statute, if we just take the words male and female out of the statute, it says the security, the names and so on and so forth of the proposed contracting parties. Well, that's the law. There it is. That's it, Dave. You just take those words out. Well, there's a problem with that. Interestingly, the two cases that dealt with in-state marriage license laws, Michigan and Ohio, both have references to man-woman or male-female. And the court did not analyze those statutes. It's very interesting. They didn't say, well, here's the statute, and here's what you do. You just take the word man and woman out, and voila, you have the rest of the statute, and that's how you get married, holding number 2. There's the law. They didn't do that. Very interesting. In most cases, like in abortion cases where there's a provision about the doctor doing something or whatever it is, they quote the statute and they say, well, here's the key word, and you take the word out and all that, and they interpret the statute. They didn't do that in this case. Why did they not? Why did they not? Why didn't they tell us, here's how you get to this new law? Other than just saying, you can get married, why didn't they say, well, here's how? They didn't explain it for us. Well, let me tell you why they didn't. There's this doctrine of elision. The United States Supreme Court has cases that are exactly like this. They use the word separability or severability, which is the concept of can you elid, can you separate, can you segregate out invalid words, unconstitutional parts, and just uphold what's left. The Tennessee Supreme Court last March said, when a conclusion can be reached that the legislature would have enacted the act in question with the unconstitutional, the invalid, part omitted, then elision of the unconstitutional portion is appropriate. In other words, here's the question. When I said, can you just take the words male and female out of the statute, the question is, well, if the legislature had passed it without those words, if those words were removed, would the legislature have enacted the law anyway? Well, do you think when the General Assembly passed the law in 1995, it would have enacted it if the remaining words, contracting parties, could have included 2 men or 2 women? Now, before you answer that question, let me tell you that sodomy was a crime. Would the legislature have authorized a marriage that would have been a crime to engage in? Now, they do some crazy things, but not that crazy. How do I know that for sure? Because I voted for that law in 1995. It was my first year in the General Assembly. In 1996, the State Court of Appeals said your sodomy statute is unconstitutional. It's unconstitutional to make sodomy a crime. You know what we did in 1996? We passed the Defense of Marriage Act that said, hey, in 1995, we said you had to be a male and a female, and in 1996, the next year, we came back 4 months after the Supreme Court, or the court struck down our sodomy statute and said, by the way, we meant man and woman. We really did mean that. How do I know that? Because I voted for it. I was the one defending it on the floor. The answer to this question, can you take the words out, is no, no, no. It would have never been passed. Why did the Supreme Court not go through this analysis? Because they would have known the answer. Nobody would have passed these marriage statutes at the time they passed them if it was going to allow same-sex marriage. Their own court precedent would require them to say the whole statute's unconstitutional. You can't just take those words out. So they just kind of over it. Said, we're not going to get into it. We're not going to explain it like we might normally because we'd get in trouble. We'd have to start overruling years and years and years of precedent on whether you can take words out of a statute. So There's that answer. Well, what's the other answer? Okay, we're issuing marriage licenses. What's the law? Well, here's a second possible answer. What did the court say? The court said, we hold same-sex couples may exercise the right to marry. So the Supreme Court just passes the law. Your law is invalid. It's gone. It's unconstitutional. You can't elide and delete the words male and female and save the statute. It's just gone. So we'll just pass a new one for you. We'll tell you what to do. The problem, my friends, is that's the court effectively enacting a new marriage license law to replace the one it said was invalid. And that's a violation of federalism and the separation of powers. That is an unconstitutional act by the United States Supreme Court, contrary to its own cases, upholding the doctrine of federalism, NFIB versus Sebelius, and separation of powers. Now, I would like to tell you that I'm some kind of genius for thinking about this, but actually the Alabama Supreme Court has a case that's pending in front of it right now. You may have read about some of the stuff Judge Roy Moore is doing. And liberals are going nuts every time he does something, but there's nothing they can do about it because he is legally, constitutionally correct. And what the Alabama Supreme Court said last March in a 6-1 opinion that did not even include Judge Roy Moore. So those of you who are listening, don't think, well, this is just crazy Judge Roy Moore. No, Judge Roy Moore sat out this case. He recused himself. So this is 6-1 of the other non-Judge Roy Moore people, okay? And I'm not saying that in denigration of Judge Roy Moore, but to let you know, this wasn't Judge Roy Moore leading some charge down here. Now, what had happened back last year in March was a federal judge had said, you have to issue same-sex marriage licenses. And so a lawsuit was brought and said, well, that judge is only able to tell the parties in the lawsuit what to do. Remember the first thing we said? You got to remember, if I sue Enoch, that has nothing to do with what Zach has to do. It's just me and Enoch. And the Alabama Supreme Court stepped in and said, yes, one federal judge is not God over everybody, and he can only bind the parties in front of the case. And so the rest of you people in Alabama who issue marriage licenses, obey the law of Alabama until the Supreme Court rules, and then we'll figure it out. But in that decision, they said this. They said the contemplated change in the definition of the term marriage so as to make it mean something antithetical to what was intended. In other words, when you delete the words male and female from the law to say that means now 2 men and 2 women can marry, that's antithetical to what was meant, what was intended. We're a legislative body. We can't change the meaning of a statute. If a statute's meaning and purpose is going to be changed, we can't do that. We're a judicial body. The Alabama legislature must do it. And he said, so therefore, that means it would appear to require nothing short of striking down the entire statutory scheme. If you're going to say those words, male and female, are invalid, then you got to say the whole thing's invalid. And then they said this, the alternative appears to allow the judiciary to declare by judicial fiat a new statutory scheme in place of the old, rather than leaving it to the legislative branch to decide what should take the place of the scheme being stricken. Who knows? Now that the statute's invalid, Alabama might say, we want to be able to marry red elephants. As long as you don't want to marry a war eagle. Or maybe it'd be vice versa. I don't know. We don't know what the Alabama legislature would do once their law is ruled invalid. But the Alabama Supreme Court saying, but whatever it is, it's not our job to do it. That is contrary, it says, to well-established state and federal principles of judicial review. So Obergefell has some constitutional problems we have to understand. It violates the separation of powers in that a judicial body is enacting a state statute. That's what they have done. And that violates the precedents regarding federalism, which prohibits commandeering state officials and branches of state government. Now, on our lawsuit page, you will see this flow chart, and it's a little hard for y'all to see here and probably impossible to see on the internet. But I want to blow up the key part of that slide, and I hope folks at home can see it. But essentially, there are 4 different things that can happen, and they pretty much all lead to the same result. And the key part is on the far right-hand side, the 3 boxes. If the state courts of Tennessee do what they should do, they should really do one of 2 things. They should say Obergefell was an unconstitutional exercise of judicial power. That means it's void ab initio, a nice Latin term, and therefore should be disregarded. Just like the marriage license law, or a marriage license you got last August, might have well gotten a piece of toilet paper. The law was invalid, the license was invalid, your marriage was invalid. Everything's invalid. You don't get something valid out of something that's invalid at the root. Or they can say, well, we can't ignore the decision, it's there, but the Supreme Court said the law's invalid, so the law's invalid. Nobody can get a marriage license in Tennessee. Now, what that will do is it will precipitate a lawsuit saying you must pass a statute for us. They're going to have to sue us and say, federal court, you have to make them pass a law because we want our marriage license. Now, I'm not against marriage licenses. But I think there are many who understand the gravity of the constitutional problem here. And many who would say, look, whether I want to have same-sex marriage licenses or not, I'm going to have them because I have chosen to do so, because the people of Tennessee have chosen to do so, not because some federal judge oversteps the bounds and the lines and tells me to do something he has no authority to do. And so we need to focus this issue to a laser beam to say, Supreme Court, overrule all your prior precedent and just come up with it and admit, I will pass a law for you. And if they say that, my friends, constitutional government is dead in America. I have tried to say to people, I care a whole lot about marriage. But as Justice Scalia said, I ultimately care more about who rules me. Because if they can tell my state, this law's invalid and here's your new one. Oh, that law's invalid and here's your new one. And oh, we don't like that law either and here's your new one. Then what else will they begin to tell me to do? And why else should we even have a legislature? Just send us down the laws you want us to have and we'll just follow them. We have to help our friends who don't care who marries whom understand that this is a grave constitutional crisis of proportions not seen in this country since the Dred Scott decision. This is worse than Roe versus Wade. Roe versus Wade, the court found a new right in the Constitution, and they said you can't have this law. Here they found a new right, said you can't have this law, and here's, by the way, the new law. Do you see how this case goes beyond what the court has done in the past? From saying no, 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 no to yes, you'll have this. This is the most significant Supreme Court decision I submit since Dred Scott. And if we won't take it on, then we don't deserve to live in this country. It won't matter who we elect as president. It won't matter who we elect to the legislature or who we elect as governor. We will be ruled by 9 unelected, unaccountable, unreplaceable lawyers on the Supreme Court that went to Ivy League schools.